Because, you know, a lot of what I get from folks is, oh God, you've been in litigation for so long, that's terrible, that's terrible, that's terrible. No, not really. Because to a large extent, we're protected. We're more protected. We're protected by the positive rulings we've had in our case, and we're protected by conduct of the federal agencies that they know that they are in court, and to some extent they have to watch their behavior. Now that doesn't mean they watch all their behavior, as we found out, because they got cited for contempt of court in our one case. But it does go a long ways in stopping some of the bad behavior. So yes, none of this is easy, but you know, we aren't standing at the Battle of Antietam with 60,000 people dying in 2 days. And we aren't fighting in the War of 1776 and in the Revolutionary War. We're fighting in the courts, we're fighting in the political arena, and we're fighting in the public arena. And my hope and prayer is that we fight as vigilantly as possible so that we don't ever get to that point. So yeah, we've been in court, we've suffered some trying things along the way, of course, as a lot of other people have who've been there with us and who've fought it in their own situations. But that is our duty, is eternal vigilance for our liberty and freedom in this country. And we get to fight it one way or the other. Each generation gets their turn to deal with these things. We were not at Normandy. We were not in the Depression. Now, we might be headed there now, but my point is you know, many generations have seen some difficult things to deal with. We should not feel persecuted because we also have to deal with some stuff. So it just depends on how vigilant we are in our own property, in our own ranches and farms, and what we want to do about protecting those. But also, with regard to the greater purpose of this country, what are we standing for? So that is why we fight the fight and why we continue. I want to start off my comments here with one idea. You know, I have a very hard time sitting still through some of this stuff because it just jangles my chimes to hear some of the things that are happening to people, and it's hard to sit still and be quiet. I have spoken to a number of legislators, including ours from Nevada, Harry Reid accepted, because he would be implicated in this. But I believe one of the quickest cures to some of these problems, if we could ever get it passed in Congress, is a one-line rider passed on a bill that Harry Reid just has to have, that allows for immunity from prosecution to be eliminated from federal employees who have criminal intent, in other words, a high level of intent, for not following the laws of Congress as written. It would completely change the tenor of Washington, D.C. if Lois Lerner could sit in front of Congress and actually be worried that she might someday be prosecuted. It would completely change the Veterans Administration if some of those high-ranking officials were actually in fear of being prosecuted. It would completely change the 200 snipers who pointed guns at the Bundy family without an ounce of law enforcement authority if they were concerned that they might be prosecuted for those actions. And I think holding federal officials accountable, not for petty stuff, but for serious crimes, would go a long ways in helping this. And I would like to see something done with that on the national level, because it would cure so much of what's happened. Quite frankly, the laws as written by Congress, whether even the Endangered Species Act, when you read the law in its plain language, it's not that bad. The Taylor Grazing Act is not necessarily a bad law. It is the way it is implemented. The second thing that is so problematic with our federal system is the Administrative Procedures Act. Because all it takes is one bureaucrat sitting in his desk, a low-level bureaucrat, local BLM manager, local forest ranger, who writes an administrative decision, sends it to you, and you have to respond to it or hire a lawyer. Walk away from whatever it is they're trying to diminish in your property rights, or hire a lawyer. And it is with that administrative power that they are able to wreak tremendous damage across the West. That's where it all starts, is with that first administrative decision by the, that's what happened with the Hammonds, that's what happened with us. We went through 3 administrative appeals beginning in 1978 all through till 1991, costing about $150,000 a piece at the time, and won every one of them, and it never changed the conduct of the agencies. So these administrative powers that these agencies have are so enormous and so arbitrary, so capricious, and they have no bearing. The administrative decisions have no bearing on the law. In fact, they're outside the law, quite frankly. So it's a complete lawlessness on the part of our federal employees that is causing the problem. It is not the laws of Congress. It is not the laws as they are written right now. It is the lawlessness on the part of the bureaucrats. And so reforms in both of those areas would go a long ways in solving some of that problem. Another quick way to solve the problem, of course, would be to transfer the administration of these lands to the states. And then we wouldn't have to deal with the Federal Administrative Appeals Act, or Procedures Act anymore, and of course then we can deal with our own state bureaucrats. But this is, these are the root, this is where all this stuff begins, is at that administrative level. And so I just wanted to mention those things. As we were talking today, I very much appreciate your PowerPoint, because you went through a series of laws passed by Congress and showed the language in each one of those laws that preserves and protects pre-existing rights. If you look at the Western public lands, quote-unquote public lands, that's their term, not mine, the Western federally administered lands, almost every bit of it has 2 things: vested stock water rights on it and irrigation water rights, and has a federally adjudicated grazing allotment almost over every bit of it. I have a map of Nevada showing the federally administered land and the grazing allotments, the adjudicated grazing allotments, and you can just put them over the top of each other. What that means is these ranchers didn't get these grazing allotments by coming in at the last minute in 1934 or whenever their grazing district was created and obtaining a grazing permit. No, they got these, our predecessors in interest obtained their grazing allotments because they were able to document that they had pre-existing rights. And most of our pre-existing rights in the West go clear back to the 1800s at some point. Pine Creek is 1865. What we have as a result of that is, if you do a chain of title on that property, you can document that you own vested rights to your water, to your forage, to your easements, to your rights-of-ways, your ditches, pipelines, and so forth, your range improvements, and so on. And with those rights, those rights were protected in every land law passed by Congress, up into, including the 1976 Federal Land Policy and Management Act. In all of our litigation, remember, we've had water adjudication, we've got the Hage v. U.S. case before the claims court, going up back on appeal now to the Fed Circuit, and we have the recent 2012 decision out of the U.S. District Court of Nevada from Judge Jones that was referenced here earlier. So we've had 3 major federal cases. The primary evidence in all of those cases, or state case and 2 federal cases, was the evidence of our title, our title and water rights. We had hundreds, I showed them to John Fallon after he was there for the bench ruling with Judge Jones. And we had 3 binders this thick of title documents that I had to testify about in that case. And it was those documents that basically documented our pre-existing rights to those lands. And we were able to prove that we weren't trespassing on federal land per se, that we were availing ourselves of our own property rights, our water rights, our vested stock water rights, our forage, our easements, rights-of-ways, and so forth. And every property virtually that has been historically settled in the West has that same exact evidence. But all too often, when we file cases in these, dealing with these issues, whether it's water or range allotments, we fail to bring that evidence into the case. And when we don't establish that we were there first, then we basically waive that protection that we have under all those laws. So it's that title work I cannot emphasize enough, and I mention it to you all because I know a lot of you guys have ranches and farms, is vitally important for both water rights and for your forage and range rights. I was asked to give a little bit of an update as to where we are in our ongoing saga. And we had some good news in December. We had a judge who, our claims court case, the one that Dad and Mom started in 1991, and later when Dad married Helen Chenoweth, that they continued with and fought through the trial stage in Reno, and carried that case for all these years. That case had a decision finally in 2008, basically of a judgment which totaled somewhere around $14 million at that time, counting interest and not including attorney's fees over the top. So that case was appealed, as many of you are aware, up to the Fed Circuit. The Fed Circuit did a very important thing which was referenced here earlier. The Fed Circuit clarified its position on the Colvin case, our neighbor in Nevada, confirming that we must be provided access to our water. Now, that's very important, especially in isolated stock water up on a mountain somewhere. If you can't get to it, if you can't access it, it is of no use to you. However, there's more to that. If you can't access it for the beneficial use it was acquired for, such as stock grazing, it's also useless to you. So that access component to that water right is vitally important. And it's important to understand that when the agencies take property, they take property by virtue of not taking the physical thing. They don't physically move that spring and say, it's not yours anymore. They merely chip away at the uses. They reduce your livestock numbers through the terms and conditions of a grazing permit. They reduce your season of use. They fence it off, claiming it's a riparian area or whatever. And they chip away at the uses as opposed to physically taking the property itself. One of the things that happens in these cases, and I'm sure Tim can speak to this, when a federal attorney from the Justice Department gets up and speaks, quite often they stand up, start lying, and never stop until they sit down. They misrepresent the cases, they misrepresent the facts, and unless you challenge that, it stands before the court. So we have a little bit of that to fix with the Fed Circuit, because that's certainly what happened when we went up to the Fed Circuit last time. So I'm cautiously optimistic about that case, but I do want to explain that case, that case has not been, it's widely misunderstood. Judge Smith's decisions are a little bit obscure to read, but let me just say it this way. He had 8 published decisions in that case. A lot of people don't get 1 published decision. We have 8 out of that case. And in the property decision specifically, while he dismissed part of our claims in that decision, he made numerous findings about our property rights. And those were never challenged by the court, or by the Justice Department, by the feds. And those findings still stand. And the Fed Circuit, it was appealed to the Fed Circuit. The Fed Circuit is binding on all of the districts of the United States courts. So that's applicable here as well. Then in 2007, well, let me back up a step. As many of you are aware, the government canceled our grazing permits. They said that we were overgrazing. Then a year later, they showed up with guns, did a mini Bundy on us, and confiscated 100 head of cattle at gunpoint, sold the cattle, and kept the proceeds. That's when we filed the claims court case. 4 months later, as you are well aware, that they filed criminal charges against Dad on clearing that ditch right of way on an old 1866 historic ditch right of way. And we had to go to the Ninth Circuit to get that reversed. So about year 2002, after we had a number of decisions come out of the court recognizing our vested water rights, recognizing, because the Forest Service, by the way, had filed on every bit of our water, recognizing all of our vested water rights, recognizing our rights of ways, easements, improvements, and so forth, Dad reapplied for a grazing permit. And of course, they denied it without cause. So he knew we were sitting there with a white elephant, a ranch of 7,000 acres private land and another 750,000 acres of range and water rights. And he knew he had to test it. He knew he had to basically commit civil disobedience, if you want to put it that way. Or maybe another way to put it is stand on those court decisions and force the government to recognize them. Because as we all know, the government is notorious for not recognizing law or not recognizing court decisions. They gnashed their teeth, they sent us trespass notices, they threatened us, that went on for years, never did anything until Dad died. And then I think they thought my brother, the estate would be easy pickings. Well, they didn't know my brother. And bless his heart, he'd sat out there very quietly, learning and studying, and none of us expected to be dealing with this case. It was Dad's case. But bless his heart, he had been paying attention, all of us had, and he was sued personally, and then the estate as well, for trespass, as we kind of expected they would do, on the federally administrated lands. So that case finally went to trial in 2012. We ended up with a month-long trial over a period of 3 months, and a decision out of the court. John, you were there for that. That was a good day, wasn't it? The jaws were dropped, everybody's jaws. And had a decision out of that Judge Jones, that basically, I'll summarize it very quickly. He ruled that he put us under permanent injunctive relief because we'd filed a cross complaint alleging that the government had been interfering with our business relationships, our contractual rights, and that we needed injunctive relief. So first of all, he put us under permanent injunctive relief like the civil rights busing cases. He then ordered us to file for a permit and the government to issue a permit. He then said that the federal government could not take those, could not cut us. Remember, the way they've destroyed a lot of people is just by cutting us enough to make it uneconomic to use those allotments. He said they had to restore our grazing numbers up to the original adjudicated levels, and they could not cut us again unless it was for an emergency such as a legitimate drought or something like that, and never permanently. And if they cut us more than 25%, they had to come to him to get the permission to do it. He found a half-mile forage right around and adjacent to all of our waters. Now that covers up a good portion of our ranch, by the way, when you map it out. He also found, like I said, restored our grazing preferences, basically restored the ranch is what he did. Then he went beyond that. And as a result of the cross complaint that we filed, he found that they had engaged in a conspiracy beginning in the 1970s when my mom and dad bought that ranch to deprive us of our grazing preferences and our vested water rights. He went on and said that he'd seen evidence during the course of that trial of racketeering, RICO. He'd seen evidence of fraud, mail fraud, wire fraud. And he ordered the BLM manager and the Forest Service ranger to show up several months later for a show cause hearing for contempt of court, for interfering with the jurisdiction of the court during the pendency of the case, including witness intimidation, including seeking remedies outside the court. So they had cited us for trespass and for the same cows that we were leasing from other people, and then they'd also tried to collect from those people by sending them trespass notices, collection notices, sending them to Treasury, trying to intimidate them into paying for the trespass charges twice, from them and from us. And proceeded to pursue those remedies outside the court. So we held them in contempt of court, and then we had a show cause hearing later. I will, following up on your favorite Forest District Ranger, Region 3 Manager, Harv Forsgren, he came and testified, and I never heard so many adjectives for the word liar, as what Judge Jones said when he did his findings with regard to the credibility findings for Harv Forsgren. But he called him a prevaricator, a liar, and several other things. I forgot all of it. And because he was questioning Harv Forsgren, had the Forest Service been in the business of trying to cut grazing permits? Oh, no, Your Honor. No, I can't remember that, sort of like Hillary Clinton. I can't remember that. No, we've never done that. I think the numbers are about the same, Your Honor, blah, blah, blah. And so anyway, the judge made those findings against him in that show cause hearing. And it wasn't long after that, I think Harv retired. So, trying to help you out down there in Utah. Of course, they always replace him with somebody worse, and he's probably got a promotion somewhere as a result of it. But anyway, so now that case, we just have oral arguments at the Ninth Circuit. The Ninth Circuit is the Ninth Circuit, so I cannot predict what's going to happen there, and it may go very well, it may go the other way. That's just the first step, or that's just the next step for us. But the interesting thing is what we had with Judge Jones in his bench ruling was he sat us down at 1 o'clock in the afternoon and said, get comfortable, we will take a potty break. If you need to take a nap, it's okay, but the attorneys will not be falling asleep. That's literally what he told them. And he proceeded for about 3 hours to read into the record the findings of the 8 published decisions from Judge Smith into the record and adopt the findings of the trial court in the claims court case, the takings case, as his own findings. So we've had 2 federal court cases with full-blown trials making the same exact findings, especially with regard to the property, the forage right, the vested water rights, the easements, stock waters, and so forth, the findings of futility, the findings of harassment, the findings of animus, and all this other stuff. He adopted those findings as his own, and then went on to make his own additional findings that I mentioned earlier. So we have 2 federal court cases going up on appeal, one to the Fed Circuit, one to the Ninth Circuit, and if the Ninth Circuit decides to utterly trash Nevada water law, then I suppose we'll be back at the claims court. If not, we might be up, it is likely that at some point we'll be up at the Supreme Court. Because if the cases are different, the likelihood of the Supreme Court having to resolve the matter, especially of access and use of those water rights, is going to become more important. So that gives you the thumbnail sketch of this little saga that we've been involved in.